A very, a very good afternoon to everyone and the guest speakers. Welcome to Mason's session on understanding geotechnical disputes and their resolution. I am Shweta Shrivastava, working in construction claims and dispute services at Mason. Over the past few years, I have been involved in many arbitration matters wherein the projects have been impacted due to geotechnical claims, specifically due to unforeseen ground conditions, which have derailed project timelines, inflated budgets, and have led to safety risks. Such disputes have led to parties questioning the core issue of who carries the burden of ground risk. With this context, today's session is focused on unforeseen ground conditions, how they are treated in the different contract conditions, and their treatment. I welcome all my guest speakers today. I will start with the introductions now. On the panel, we first have Simon Crashaw. He is barrister at Atkin Chambers. Simon specializes in construction, engineering, infrastructure, energy, utilities, professional negligence, and commercial disputes. He has wide-ranging experience in domestic courts, arbitrations, mediations, and adjudications. A significant portion of his experience is in international projects, acting as a sole counsel or being led by senior sales in the Middle East, Asia Pacific, and elsewhere. Simon is ranked as a leading junior in the Legal 500 for Construction UK and Middle East, and Energy UK Directory, and Chambers and Partners UK for Construction. I welcome you, Simon. The next on the panel is Slava Kiryoshin. He is partner at HFW. He is a highly specialized, recognized energy and construction dispute specialist in the MENA region, having represented clients in multi-billion disputes. Slava's clients include national and international oil and gas companies, refining and petrochemical companies, EPC contractors, power industry participants, and oil and gas service companies. Slava advises regularly on all aspects of energy and construction projects, from inspection through completion, and all aspects of dispute avoidance and resolution. His recent work includes oil and gas processing facilities, full field development infrastructure, drilling contracts, power plants, LNG facilities, refineries, and major railroads. The next we have on the panel is Alex Nikolek. He is director at A Squared Studio. He is a geotechnical expert. He is a UK-based chartered civil engineer and founder of A Squared. Alex brings vast experience in geotechnical and substructure engineering. He has led multi-design teams in projects across 60 countries with a strong focus on sustainable design and innovative ground engineering solutions. I welcome you all again. We will keep last 15 minutes of the session for Q&A session with the participants. So the session will cover the four main topics. The first topic would be understanding unforeseen ground conditions. The second would be forcibility, assessing the tender side data. The third topic of discussion would be the test of experienced contractor when it comes to forcibility of site conditions. The last would be an interesting case study wherein the panelists will have assessment of a particular case. So let us begin the session now. The first topic is understanding unforeseen ground condition. So basically what happens beneath affects what happens above. There are many advancements in site investigation these days. However, unforeseen ground condition remain number one issues which has led to various disputes in construction projects. Now let us understand this from Simon as to what are the unforeseen ground conditions and how are they typically defined in standard forms of contracts or regulations.
Thank you, Shweta. Well, unforeseen ground conditions can include a wide range of different situations. Typically, standard form contracts such as FIDIC and NEC refer to adverse physical conditions, which would include adverse ground conditions. The FIDIC form goes further in defining that as to mean both natural and man-made physical conditions, as well as physical obstructions and pollutants, including subsurface and hydrological conditions. So that could include the level of water in a river, for instance, but it excludes climatic conditions such as rainfall. So some common examples of adverse conditions which a contractor might seek to claim for would be rock that is encountered during excavation below or above the levels that were anticipated, soft or unstable soil with poor bearing capacity, underground voids, high groundwater level, waterlogged ground, contaminated soil, uncharted utilities, and unexploded munitions. So that gives you a sort of broad overview of what unforeseen ground conditions are.
Thank you. But in continuation to that, according to English law, who bears the risk of ground conditions?
Yes, so the default position under English common law is very unfavorable for contractors because in the absence of any express provision in the contract allowing recovery for adverse ground conditions, it's the contractor who assumes all of the risk of any ground conditions that are encountered at the site. Now, there are some limited exceptions to this. So there are cases where even despite the lack of a contractual clause permitting recovery for unforeseeable conditions, it has been successfully argued that the employer gave an express warranty that particular ground conditions would exist. And in certain circumstances, the contractor might also be able to make a claim for misrepresentation based on inaccuracies in the information provided at tender stage. But claims based on the existence of an express warranty or misrepresentation rarely succeed because the information provided by the employer is often not expressly incorporated in the contract, or the information is heavily qualified or subject to disclaimers. And the English courts have held that a statement can only amount to a warranty if it's sufficiently defined and unqualified. And that case, there's a case on that that's called Cooperative Insurance Society and Henry Boot, Scotland. Now, notwithstanding the default position under the common law that the contractor bears all of the risk, it's generally considered preferable from a commercial perspective for the risk of unexpected ground conditions to be borne by the party who gains the long-term benefits from the project. And for that reason, general practice internationally in most forms of contract is to depart from the common law position and provide that the employer bears at least some risk of adverse ground conditions. And that's achieved through the mechanism of an express contract term permitting recovery for adverse ground conditions. Now,
Yeah, thank
typically
you.
such clauses refer to adverse physical conditions that were not reasonably foreseeable by an experienced contractor. The NEC contract uses a slightly different formulation, which is potentially less generous to contractors. Clause 60.112 of the NEC refers to physical conditions which an experienced contractor would have judged at the contract date to have such a small chance of occurring that it would have been unreasonable for him to have allowed for them. So under the NEC, the contractor is at risk for all conditions except those that have a small chance of occurring. And it's at least arguable that this imposes a greater burden on the contractor than the more typical provision that permits claims to be made for conditions that are not reasonably foreseeable. So I hope that
Uh,
answers the
yeah, yeah,
question.
yeah. So, yeah, that's quite well explained. Moving on to Alex. So, Alex, like you are a geotechnical expert and would have encountered similar situations, similar issues on your projects. So, could you give us some examples of common unforeseen ground conditions which you have encountered in your projects?
Yeah, absolutely. Hello, everyone. So typical instances of distress with unforeseen ground would arise with made ground anthropogenic deposits. So, especially in congested urban settings, rich history of many cities, subject to redevelopment. These can be, as Simon said, geotechnical and geoenvironmental. You could have it's quite sharp variation in conditions across very small distances. Depending on the history, obstructions are a very significant problem on urban engineering. In terms of natural issues that arise, so these are based around rivers, hydrological features, and these come with their own. Can you still hear me?
Yeah, we can hear you fine. Yeah.
Oh, sorry, apologies. I lost you on my screen. So weak alluvial deposits commonly occur. So this is in vicinity of rivers. And again, we can have some quite sharp variations. We've got a number of projects in London, for example, where it dips away very rapidly and you don't typically pick it up with normal means of investigation. As I mentioned, hard strata introduce a problem more for construction rather than the foundation. The foundation benefit, of course, from having very competent materials, but installation of below ground space, basements, etc. So it's a very common issue. Something we see across the Middle East and across.
I think he has some connection issues. Alex, are you there?
Yes, can you hear me?
Yeah, we can hear you.
Apologies. At what point did I get lost, Shweta, just so I can kick off again?
So you were explaining about the obstructions which are, faced on different projects and what happens in Middle East.
Yes. Okay. So basically, voiding insoluble materials is another common issue that we sort of encounter that is very difficult to quantify by knowledge of a formation or hydrogeological conditions that would have caused it. But I think I just wanted to highlight that groundwater is frequently the killer, as we call it. Normally, in that compounded element of unforeseen conditions, groundwater has some pretty specific role. One thing just to close this point on is unknowns in known ground conditions cause the greatest distress when designers and contractors take known, in commas, known conditions for granted. If we are on a very remote site in unknown conditions, typically there's a greater level of rigor that's applied. So it's just, as I said, in those known formations, I think people sometimes just take for granted that they'll encounter something foreseeable and don't do the level of due diligence that would be required. Apologies for breaking out there. I don't know what happened.
So that's quite interesting. So last year I worked on a project. It was a railway project in Africa, and there also we had the same issue of unforeseeable, the ground conditions and rock condition. So that was one of the interesting cases I worked on last year. So yeah. So
Interesting.
my next question is to Slava. So like we are discussing right now, like these kind of geotechnical claims are leading to um dispute between the parties. So, in your opinion, in your experience, how are unforeseen ground conditions typically treated in terms of additional time and cost in English law? And since you're working on a lot of Middle Eastern projects, how it compares with the contract in the Middle East?
Sure. Thank you, Shweta. I think one of the, well, there's two caveats that I need to make to my answer. There is a slight but important difference between unforeseen ground conditions and unforeseeable ground conditions. And sometimes contractors take that for granted. And the second issue that we need to consider is whether those unforeseen and even unforeseeable ground conditions actually cause any sort of delay or damage, because that's also sometimes a tag on in different claims that I've seen in the past. And just for the sake of transparency, I work for both contractors and employers, so I've seen the same arguments being run from different directions, so to speak. The general position under English law is certainly if there is a clause such as the one that Simon was discussing earlier. So if there is such a clause, then we're talking about a breach of contract and we're talking about contractual damages with a delay event. So that would effectively mean time plus money, but the money element comes as damages. So there is no element of profit. It should not be coming as a contractual rate in effect, unless obviously the parties have agreed on something very specific in their contract that, certain additional excavation is done by a particular rate. So when we're dealing with lump sum contracts, typically I would see this as going on damages. I think the position is broadly similar in the Middle East. There's potentially more flexibility, certainly with Middle East laws. So if we're talking about the Gulf laws, for example, we have the additional benefit of the duty of good faith, which permeates every single contract. And well, English law is not quite there, but I think there's kind of peaks and troughs in those developments. And there are other provisions in terms of certainly unforeseeability and excess costs, as well as employers enforcing certain rights, which would lead to disproportionate damage to contractors. So I'd say the Middle Eastern laws are probably more favorable to contractors overall than English laws. But yeah, there's quite a lot of issues that typically come out of unforeseeable ground conditions.
Thank you, Slava. That was very insightful. So moving on to our next section, which is foreseeability with respect to assessing tender site data. So let me give you some background to this topic. So soil information which is provided by the employer during tendering stage forms a crucial information for assessing the risk of unforeseen ground condition. However, many a time it just happens like the case of unforeseen ground conditions occur because of factors such as limited time available with the contractors to conduct their own geotechnical investigation to verify the data given by the employer. Sometimes the geotechnical information is not that comprehensive. Sometimes the tender boreholes are not taken at the proper location, proper position. So they are they are widely spread across the site. So the information is not available to that extent, helping the contractor to understand the site in a full manner. However, at the same time, there are certain, typical clauses which are, there in the contract, which regarding the allocation of risk between the parties when it comes to unforeseen site conditions. So let us look at one of the typical clauses in an EPC contract, which you can see on your screen. Here, the clause states that number one, the contractor shall be responsible for interpretation of site data. Number two, it says to the extent which was practicable, taking into account cost and time, the contractor is responsible for obtaining all necessary information, risk, contingencies, everything which affects the tender or works. Thirdly, it states that to the same extent, the contractor shall be deemed to have inspected and examined the site, including the form and nature of the site, including subsurface condition. In continuation to this, the contract clause also states that the contractor shall be deemed to have been satisfied himself as to the correctness and sufficiency of accepted contract price. Number two, it states that accepted contract price amount is based on the data, interpretation, necessary investigations, examinations conducted by the contractor during the bidding stage. There is a modification in this particular clause. At the end, it also states that accordingly, the contractor shall have no claim in this regard. So, with this particular typical clause in mind, my first question is to Alex. Alex, is it a common practice or practically possible for a bidder to conduct its own geotechnical investigation for verification of geotechnical data provided by the employer in the bidding stage?
Look, it's a very good question. It's very common for clients to throw in our experience, all encompassing, in some cases unreasonable clauses relating to verification of the ground or validating what's been provided as part of the tender submission. It is a bit, to some extent, project scale dependent, what can be or cannot be achieved. However, I think it's clear that it's extremely difficult for a contractor to undertake any due diligence over and above a more comprehensive desk study or gap analysis and to point this out. And it's obviously a combination of cost and time. But even putting cost aside, and if that can be kind of sewn up in some acceptable fashion to the contractors providing the submissions, obviously large infrastructure schemes, ground investigations, even if phased or supplementary, can take many, many months. Even for a plot-based buildings project, it could be in the lower number of single-digit months to get data. So it's very difficult in that regard. Additionally, the third point would be the technical know-how. So on the client side, with an engineering team appointed, there'll be the knowledge the desk-based assessment that was done, the planning process that they've been through. There'll be a whole load of constraints that would have driven the scoping of an investigation. So it's very difficult for a contractor to turn up and blindly supplement this, because it's not about just carpet bombing a site with boreholes. It's more about understanding areas of risk where you may have particular features, or the likelihood of encountering features that are adverse sort of is greater, that you wish to cover. So in summary, it's extremely difficult position to be in for any contractor.
Thank you, Alex, for that. Slava, next question is to you. So, like in this particular case, like if you see in this clause, the contractor is expected to do its own site investigation. However, as we already discussed in the introductory part of this particular topic, the information is not basically complete. However, the contractor has no opportunity to take up the site investigation, and he has to rely on this geotechnical information given by the employer in the formulation of its bid. So in your what is your view on the um, issue of reliability of contractor on the in the on the geotech data given by the employer during the bidding stage? What are the risks of that? What is your view on this particular issue?
I think uh, it's a very harsh answer, but I think it needs to be heard. The risk here is going to be firmly on the contractor. I think Simon quite clearly addressed it by saying that actually, as far as English law goes, contractors are under an implied risk unless there's an express warranty, sort of rely upon information provided by the employer, of which there isn't anything here. So I understand the practical elements of this, and I have a little anecdote which I'll share in a second. But on the legal side of things, this will be squarely within the contractor's remit. And unfortunately, English law goes as far as to say, well, you can price up an impossible thing to do if it turns out that it becomes impossible after you've agreed to do it. So in my opinion, certainly here, the contractor would be, well, very optimistic. It would basically be a gamble for them to take this on and rely on the fact that the employer has given them some information that was available. And it happened to me some years ago, because Simon mentioned unexploded ordnance as basically mines. A client of mine, a contractor, was provided with a demining certificate in one of the Middle Eastern jurisdictions, but that demining certificate was very much limited to a specific area. Once my client went on site, they were able to find a warehouse full of mines just within 10 meters radius of that area. So in effect, we knew from the get-go that actually we're going to have to start all of this from scratch again. And we were unable to claim for it because there was never a disclaimer by the employer or the site owner in these conditions to say that it was in fact, rely upon information that there are no mines in the area. They basically said this area is clear and so on. And I think there are cases, so the Abraskan case, and I'll probably give it to Simon because I know he worked on that case, that they had a similar position when the contractor relied upon something they shouldn't have.
Yeah, this one is quite a tricky issue actually. So, moving on to Simon, can you share a case with us where a contractor could successfully claims additional time and additional cost due to unforeseen ground conditions?
I'm on mute. Surprisingly, there are actually not many decisions from the English courts, at least, where a contractor has successfully claimed for unforeseeable ground conditions. And that's partly because the vast majority of cases of this nature are determined in arbitration proceedings, which are private generally. Now, one publicly reported case where the contractor did achieve a small measure of success is the Obriscon and Government of Gibraltar case that Slava just mentioned. Now, that case concerned the construction of a tunnel under the airport runway in Gibraltar. I was junior counsel for the government in that case and had the privilege of spending several weeks on the site in Gibraltar at the beginning of 2013. So I'm quite familiar with the case. The claims brought by the contractor actually included 3 separate claims for adverse ground conditions. One was for the volume of contaminated ground encountered during the general excavation of the site. Another claim was for contaminated groundwater. And finally, there was a claim based on the depth of rock that had to be excavated during the construction of the diaphragm walls for the tunnel. Now, the most interesting and commonly cited parts of the judgment concern the claim for contaminated ground, which the contractor lost. But the contractor was partially successful on its claim for the volume of rock encountered during the excavation for the tunnel walls. And in that case, the site investigation report that was incorporated into the contract in that case included information from 11 boreholes within the area of the diaphragm wall construction. And the borehole information included descriptions of the material found at various depths, together with in situ cone penetration tests, standard penetration tests, and pressure meter tests. The difficulty was that there were considerable inconsistencies between the descriptions of the material given in the borehole report and the SPT tests. So the material was generally described in the borehole logs as stiff or very stiff clay, but in many cases, the SPT tests indicated the presence of harder material than would be suggested by that description of stiff clay. The main difference between the position of the geotechnical experts for each side was how much weight an experienced contractor would place on the descriptions of the material in the borehole logs compared to the SPT tests. The contractor's expert contended that it was possible to reconcile the SPT tests with the description of the material because the SPT refusals could conceivably, in his view, have been caused by thin bands of mudstone within the clay. And so it was suggested that an experienced contractor would not necessarily have considered the SPT results to be indicative of a widespread presence of harder rock. And the contractor's expert concluded that 800 cubic meters of rock encountered was unforeseeable, whereas the employer's expert, who placed much greater weight on the SPT tests, was of the view that none of the rock encountered was unforeseeable. Ultimately, the court came down somewhere in the middle, but closer to the contractor's position, deciding that 500 cubic meters of rock was unforeseeable. So that's an example of a case in the English courts where a contractor was partially successful on its claim for ground conditions.
Thank you for that. It was quite interesting. Even I am, assessing this particular case study for my, LLM in construction law. So it's quite helpful and it's quite, useful to hear this from you as well. Thank you. Moving on to the next topic. The next topic is about the test of experience contractor. So many times the forcibility of site conditions is linked with the experience of the contractor. So in a similar manner, we have a typical clause in an EPC contract which states that if during the execution of contract, the contractor shall encounter physical conditions or artificial obstructions which could not have been reasonably foreseen prior to date of contract agreement by an experienced contractor on the basis of reasonable examination of the project data, including the bore test provided by the employer, and on the basis of information that it could have obtained during the site visits. So with this particular clause in mind, my first question is to Salava. In your experience, how is the term experienced contractor defined in different forms of contract?
Well, that's an easy answer, actually.
Yeah.
It's not. It's not defined
It's not
anywhere,
defined.
and
Okay.
yes, so it's not certainly not defined in FIDIC, and there isn't a standardized definition that you would see in what I would say bespoke EPC contracts. So by their nature, they're not standard, but even then, the term experienced contractor is kept somewhat wide. I mean, as lawyers and in certain common law, we can basically deduce that it's a contractor that has to have experience of similar works, potentially in similar locations and conditions. So there's no point in talking with, I don't know, an oil and gas contractor on matters related to civil construction, or foundations contractor talking about processing facilities. They have to have the relevant experience in that information. The one thing that catches contractors out more frequently than they would care to admit is actually published information. So sometimes people forget to check what exists out there outside of the employer's tender documentation, but that would be taken into account when you're talking about an experienced contractor. So generally, you would expect a contractor to check all of the public information that's available about the region, maybe even the site, or certain types of underground conditions. And I believe that's all that I could say on it. I think NEC, Simon can correct me if I'm wrong, I think NEC mentioned something around a small chance of something happening, but I haven't really encountered that in my practice here in the Middle East. It's usually an all or nothing type play.
Okay. Simon,
Yes.
would you like to add anything on this topic? Yeah.
Yeah, well, I think it's important to highlight that the reference to experienced contractor is essentially there to clarify that this is an objective test. So it doesn't matter what the contractor bringing the claim personally foresaw or was capable of foreseeing. The court or tribunal must instead apply an objective test and consider what a hypothetical experienced contractor could have reasonably foreseen. Now, I think a more interesting question arises as regards the meaning of the phrase reasonably foreseeable, which is adopted in many forms of contract, including FIDIC. The use of the word reasonably is inherently flexible and somewhat open to interpretation. So is it only reasonably foreseeable if there is a substantial risk of the event occurring, or is something more remote reasonably foreseeable? Because what's considered reasonable to one person may be entirely unreasonable to another. And so the phrase really does give a tribunal a great deal of flexibility to come to its own decision on the merits of the case. But the English courts have given some guidance on this in a way that is fairly unfavorable to contractors. So the first instance decision in the Obriscon and Gibraltar case appears to adopt a test of whether there is a realistic risk. Mr. Justice Aikenhead held that an experienced contractor could have foreseen that there could realistically be substantial quantities of contaminated ground. And the concept of a realistic risk seems to go beyond what is probable or likely. It suggests a contractor must allow for situations that might only possibly occur. And when the case went to the Court of Appeal, Lord Justice Jackson went even further than this, declaring that the contractor needed to make provision for a possible worst case scenario. And he suggested that the contractor should have made allowance for a proper investigation and removal of all contaminated material. Now, in my view, it's questionable whether this extreme worst case scenario test would be adopted in future cases. It's not clear that Lord Justice Jackson's comments were intended to form a binding part of his decision, because he was merely purporting to summarize, somewhat inaccurately, the judgment issued by the lower court. And if contractors are really expected to allow for the worst case scenario, then contractors are barely in a better position than they would be under the default common law position, where they're liable for all ground conditions. So yeah, I think that's what I would have to say on the question of experienced contractor and foreseeability.
Simon, in continuation to that, when we are talking about the unforeseen ground condition, what kind of evidence is typically used to prove or disprove foreseeability?
Is that for me?
Yeah, it's for you. Yeah.
Well, primarily, the issue is not often determined by reference to expert evidence from geotechnical experts. So the experts would typically produce written reports and would then be subject to cross-examination at the merits hearing. Now, I think it's important to highlight that even where the tender information clearly identifies a specific depth or volume of material at a given location, it does not necessarily follow that any deviation from those levels encountered during construction will give rise to a valid claim. And that's starkly illustrated by some of the English cases. So again, going back to the Obrascon case, in that case, an environmental statement had been shared at tender stage and had been expressly incorporated as part of the contract. And that environmental statement contains an analysis of the information available in relation to contaminated ground. And it even made an assessment of the volume of contaminated ground likely to be encountered during excavation. And the contractor was actually told to make an allowance for 10,000 cubic meters of contaminated ground. But despite that clear statement, both the High Court and the Court of Appeal held that the contractor was not entitled to simply rely on the assessment of 10,000 meters cubed from the environmental statement. And the courts held that the contractor should instead have made its own reasonable assessment of the physical conditions that may be encountered. And they concluded that the quantity of contaminated ground that was reasonably foreseeable was substantially greater than the 10,000 cubic meters given in the environmental statement. And another decision of the English High Court, which adopts a similar uncompromising approach, is Van Ord UK Limited and All Seas UK Limited, which is from 2015. In that case, Van Ord brought a claim against All Seas for disruption and prolongation that occurred during the construction of an onshore gas export pipeline in Scotland. The results of a probe survey had been provided to Van Ord during the tender process and identified depths of peat at various points along the intended route of the pipeline. But during the construction, the contractor generally encountered a greater depth of peat in the southern section of the route than had been shown in the probe survey. And that meant that their original intended method of construction could not be used. So Van Ord essentially brought a claim based on the difference between the depth of peat shown in the survey and the depth of peat actually encountered. But Mr. Justice Coulson determined that that approach to the claim was not appropriate. The contractor was not entitled to rely on the precise levels shown in the survey. The judge instead held that the contractor was reasonably expected to assume that there could well be more or different such pockets of peat in the ground. And that approach has been endorsed in a subsequent decision of the High Court in 2020, which concerned asbestos contamination. So, as you can see from these decisions, contractors don't necessarily have an easy task in trying to establish a claim for unforeseeable ground conditions. The quality of the expert evidence put forward by the contractor is often decisive. And interestingly, in the Van Ord case, the contractor decided not to provide any geotechnical expert evidence. And it's clear from some of the comments that the court made that the court felt that this adversely affected the credibility of the claim.
Thank you for sharing that. Okay. Moving on, my next question is to Alex. Alex, I have a technical question to you. The tender documents generally include a basic geotechnical study and a limited borehole data spaced widely apart usually. To what extent can an experienced contractor supplement sparse geotechnical data during bidding stage?
I suppose this is connected to the project program and the method of procurement that's adopted on a particular project, where the allowances have been made for the contractor to undertake supplementary investigation as part of some interim or early part of the appointment or as part of the main appointment for the works. On the presumption that there is no allowance and there's just a harsh contractual clause lumping everything onto the contractor, again, it reverts back to what I mentioned earlier. It's very, very difficult to supplement any existing investigation or desk-based review. There are, however, some investigative techniques that are quite advantageous. And these include broader coverage by geophysical techniques, for example. So your typical ground investigation out there, just in summary, is to say undertake some trial pits, some boreholes, and you're sampling the material at very discrete locations at a given spacing that's sensible for the particular project. What the geophysics techniques do, whether you're using radar technology, whether you're using microgravity technology, you are scanning your site. Okay, so whilst you're not able to get all the design parameters that you would get from an intrusive borehole, which takes the material from out of in situ condition, you test it, etc. You have your in situ testing, like Simon described on the other example project. You are, however, able to check whether you're getting any variation or identify any localized anomalies, which no means of discrete investigation could help you with. Additionally, geophysical techniques are very rapid. So frequently you are moving a piece of equipment like you would a lawnmower across a site and scanning the conditions beneath. And many of them have quite significant depths of penetration. So multi-surface wave analysis, and I don't want to go into detail, but can penetrate up to 30 meters of formation. So you can identify any abnormals, any anomalous conditions, and to some extent validate against the information that the client has provided. So obviously, if you have a series of boreholes and you've set out a ground model and that's informed your tender submission, in a matter of a week or two, you could potentially supplement it with a bigger picture from a geophysical method that would identify an area where either, hard rock deposits are much shallower, or voiding is present, or something of the kind.
Yeah, thank you. That was quite informative actually, and quite technical as well.
Yeah, apologies.
So that's okay. 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 Next we have a case study. We just move my screen. Yeah. So all of you are going to assess a particular situation. Then I'll pose some questions to you, and you can provide your assessment as required. So this case study uh, is about encountering the hard rock strata at shallow depths. So in this particular contract, there are three key clauses which I have pulled out from a particular case. So here, clause A is states that information or data to be supplied by the employer shall be deemed to be accurate. This is from one of the clauses. The other clause states that the contractor confirms that it has entered into the contract on the basis of a proper examination of site data and on the basis of information that the contractor could have obtained from a visual inspection of site. Ultimately, the contractor has to acquaint himself with the site conditions. That is clause B. Clause C is about unforeseen ground condition. It is similar to what we have seen with the experienced contractor clause, but at the end, it also adds on and says that on the basis of the information it could have obtained again from a visual inspection of site. So these are the three clauses which are from this particular contract. Now let us look at the facts of the case. So the incident is the contractor encountered hard rock strata at shallow depths across several locations. This presence was not indicated or not reported in the geotechnical reports and drawings given during the tendering stage. The contractor's position is that the geotechnical data given by the employer was inaccurate. Secondly, it states the board logs were inadequate for ascertaining ground conditions as there were no exact board logs at the affected locations, and it qualifies as an unforeseen ground condition under clause C. Third, the contractor has claimed for extension of time, increased cost for change in foundation time, and deploying specialized equipment cost. Whereas the employer's position is that contractor had full opportunity to inspect the site and raise concerns during bidding stage, which it did not. Clause B states that the contractor is responsible to acquaint themselves with the site conditions. The second part is the employer's main point is it is an EPC contract and the contractor is to bear the risk of such ground condition. He is responsible to interpret data as an experienced contractor. So these are the facts of the case. So coming to that, my first question is to Alex. So here they're talking about visual site inspection. So could you give your comment on this particular means of assessing the ground condition at site? wherein they're talking specifically about the visual inspection of site. And the second part of the question, I'm sorry, yeah, would be what do you think a prudent contractor could do in this particular case in order to submit a complied bid submission?
Yeah. So first part of the question is obviously very difficult to gain anything from visual inspection unless you have some X-ray vision. However, of course, an experienced geologist, an experienced engineer working for a contractor could identify selected features with undulations in the ground. It can be vegetation varying depending on depth to rock. Any outcropping of materials. So if materials are outcropping, popping out near the surface, it can be a sign that obviously there's variability and you could have areas where it's a lot shallower than anticipated. I suppose the second part to your question, it's a relatively simple answer, dare I say. So the balance of risk was formulated relatively clearly in your kind of introduction. The question that stands out is how can something so shallow not have been proven or disproven by the client's initial investigative efforts and desk study. And codes will, all around the world, speaking about UK and Middle East, say specifically, will typically contain, minimum extent and depths of investigation that would apply to different structures that are linked to their geometry and scale and type of loading. And even if you're in an area of the world where you don't have such notes in codes, there'll be an acknowledged or accepted zone of influence that a geotechnical structure mobilizes within the ground. So I suppose a prudent and experienced contractor, in addition to doing a more extensive desk study within the time constraints of a bid period, it would be a matter of raising clearly the inadequacy of the investigation in a friendly fashion, constructive fashion, and identifying those potential risks that could arise and highlighting how that could be mitigated. And then obviously a conversation can start about whether any pre-award additional investigative efforts would be sensible, or having a very clear-cut baseline to which the contractors work in. So we've got a number of large infrastructure projects that we've been involved with where the client eventually does agree to a baseline scenario, and anything below or above that leads to some form of identification, acknowledgement, and compensation.
Okay. Just out of my curiosity, so have you come across such kind of clause in any of your projects?
Yes, absolutely.
Did you? Okay.
Yes, absolutely. It's common in many specifications that, visual inspections, the contractor will satisfy themselves of X, Y, Z based on inspections that clearly would not enable anybody on this planet to identify what exactly is going on below ground. So there's almost like a missing link. As I said, there is some merit, of course, of doing a site walkover, and that's what we start off desk-based studies with. But to have that kind of statement in place as a means of satisfying yourself of the sufficiency of an existing pre-tender investigation is unreasonable, in my opinion, at least.
Okay. Thank you for that.
Thank you.
Slava, my next question is to you. You have already covered this particular point about rely upon information, but in this particular case, the conditions expressly state that geotechnical data is deemed to be accurate for the purpose of the contractor, and in this case, the contractor ultimately relied upon this deemed to be accurate information. So, to what extent should the contractor be at the risk of unforeseen ground condition? In my understanding, if I read this clause, this would be a kind of warranty, but we would like to hear more from you.
I mean, it depends whose side I'm arguing on, to be honest, because you can argue this clause both ways. So if I'm the contractor, I'm obviously going to be taking the approach which you've just mentioned. I was provided with data. It's rely upon information because it does say that it's deemed to be accurate. There is no hard rock strata in that information. And as Alex said, there's nothing I could have done. I'm not Superman. I cannot use my X-ray vision to see what's under there. And you owe me time and money. If I'm the employer, on the other hand, I'm going to be saying, well, did you do a desk study? Did you have a check whether there should be anything there? Are you being experienced enough? And in any event, the borehole locations are the borehole locations. That doesn't guarantee something else unless you can find hard rock in the exact same place where I gave you the borehole data. You're not entitled to anything. So realistically, there will be quite a lot of detail, I think, of the same types of questions that we've been discussing on. So, you know, the experience of the contractor and also the reasonable foreseeability, not so much the unforeseeable or foreseeable events. Clearly, this is not something that that is there in the data. But was it reasonable enough for a contractor of that caliber to make a different assumptions? Because you cannot just pretend and close your eyes and say, well, you know, rely upon information that says something else. I don't know anything. So there are arguments going both ways, but this is a pretty, I'd say this is a pretty good warranty. I haven't seen so many of these in the Middle East where the employer would go as far as to say, oh, well, this is deemed to be accurate. Because typically they would try to hide behind some sort of carve out and try to throw the geotech experts under the bus by saying, well, they're not part of us. Don't rely on anything that they say.
Thank you. Moving on, Simon, my question to you is, in this particular case, what changes would you recommend in the contract clauses to deal with the risk allocation effectively? Another part of the question is, what are the steps a contractor can take to protect their position in order to deal with these kind of risks?
Yeah, well, one approach which I think Alex touched on briefly is to use a geotechnical baseline report. And that's used to define with much greater precision what is deemed to be foreseeable. So the baseline can be hypothetical, you know, in lieu of actual data, or it can be based on some, you know, investigations. But either way, it allows the contractor to price for a known set of risks with the comfort that anything encountered beyond the baseline can be recovered. And that approach provides greater certainty for both parties and very much reduces the possibility for claims. Even in the absence of a geotechnical baseline report, in light of the court decisions that I mentioned earlier, it would be beneficial for the parties to give thought to whether the degree of foreseeability of the ground conditions should be more clearly defined beyond the standard stock phrase of reasonable foreseeability. And then aside from influencing the contract terms, there are other steps that contractors can take to put themselves in a better position to pursue claims for adverse ground conditions. So for instance, having a clear documentary trail relating to the contractor's own interpretations of the tender information should significantly improve the contractor's position. When reviewing that tender information, the contractor should record for later reference all interpretations, assumptions, and conclusions that he's derived from each document and how this has influenced his tender allowance. If the court or tribunal sees that and accepts that the contractor has carefully considered the tender information and reached reasonable conclusions based on the information, it's much less likely for the tribunal to find that adverse conditions that were subsequently encountered were reasonably foreseeable. So, for instance, it's clear from the judge's comments in the Obrascon case that the lack of any analysis by the contractor of the tender information was a significant factor behind the rejection of the contractor's claim for the contaminated ground. The court was very critical of the contractor's failure to carry out any independent assessment of its own in relation to the tender information. And I would say another important lesson to be taken from the Van Ord case is that the courts generally expect claims for unforeseeable ground conditions to be supported by expert geotechnical evidence. So contractors should seek the best possible expert advice and input at an early stage during the preparation of the claim. And that will avoid changes to the technical arguments underpinning the claim at a later date, because an evolving or changing claim can often serve to undermine the credibility of the contractor's position. So I think those are all steps that contractors can take to try to improve their position.
Thank you. So we are nearing the end of the session. So, since time is limited, we will take one question from the participants. Uh, this question is raised to Simon and Slava, both of you. The question is, how do you advise clients on managing risk related to unforeseen ground condition in terms of insurance and warranties?
I'll try to go first.
Yeah.
In terms of insurance, it depends on some very specific projects. I haven't seen too much available insurance out here in the Middle East on, let's say, general civil infrastructure type projects. There are some unforeseen ground conditions which influence, let's say, oil and gas drilling operations, but that's a different scenario, and there's very specific insurance that deals with that in terms of pollution and cost and so on. In terms of warranties, that's a very tricky one, I would say. And I think I'm sort of compounded by the fact that I am based in the Middle East and the fact that I work with energy infrastructure, which is typically government-led. So the warranty is basically take it or leave it. That's as much flexibility as the employers here have in terms of ground conditions. They'll basically not take on any unnecessary risk for themselves and expect contractors to price it in. I mean, we've seen some limited differences from this, and obviously what Simon and what Alex were talking about in terms of a centralized database. I mean, that's becoming very very apt for certain projects that we have, and certainly the Emerald book, I believe, in FIDIC is looking to address it in a similar fashion. But that's still very much a work in progress, and the more influence that contractors can exert over the employers during tender negotiations, the better the overall industry outcome will be. But unfortunately, at the moment, there's very little that contractors can do to shift that risk in a practical sense. I don't want to get too theoretical, academic about it, but in a practical sense, I haven't seen too much of a shift on the risk of ground conditions. I don't know, Simon, maybe you've seen something else on this.
No, I think I would agree with your comments. I think I haven't come across scenarios where the ground risk has been effectively insured. So, you know, but so I don't have any practical experience of that. In terms of warranties, you don't. It's not very common to see an express warranty in the contract that the ground conditions are accurate from the employer, because it's not in the employer's interest to give that sort of warranty. And generally, contractors, when they're tendering for these projects, are not in a stronger bargaining position as the employer. So the employer can effectively dictate the terms because it's got, you know, 10 other contractors competing for the work. So if one won't accept these terms, another one will. So contractors are in a very, very difficult position.
That's true. So that brings us to the end of the session. So I would like to thank our guest speakers for sharing the experience today and analyzing, you know, different situations which have been discussed in this forum. Thank you very much for your time, and it was a great session. There are few questions which our participants have raised. We will email those questions to you, and if you could revert to those questions as and when you have time. Thank you very much again. Thanks for joining us today.
Thank you.
Thank you.
Thank you,
Thank you,
Shweta.
everybody.
Good day.
Have a good
Thanks.
day. Bye-bye.
Bye.
Bye.